Yes, sir, it is visible.
Thank you. Okay. Now this session, we will basically today's first opening session, we are focusing on the future, okay, the way forward in terms of what to expect in the coming, in the current year 2023. There has been a lot of talk for the last 1 year or so about many amendments being thought about in the IBC. There was a lot of expectation that in the last parliamentary session, the amendment would be taken up, but it did not happen. Probably, but maybe the consultation was still not complete. Today's session, we are going to discuss or look at those issues or proposals which are being considered for amendment in the IBC. These are largely based on media reports. They are not an official document or anything which has come out of the government or parliament. But still, knowing the background behind most of these proposals, we know that they are largely based on what different stakeholders have proposed over a period of time. It's been said that the government has held a lot of consultations with a lot of stakeholders from various aspects of the insolvency process, which includes creditors, industrialists, IPs, legal fraternity, etc., and has finalized a set of recommendations which would hopefully get translated into an amendment. The structure which we will follow, we will broadly look at what these proposals are. Firstly, what are the objectives behind what is being proposed? Then we will try to dissect each one of them, learn what is going to has been proposed for as an amendment. Maybe discuss whether it should be that way or something different, including what could be the pitfalls or the downsides of any such amendment. And then this will be one part of the session, probably 1/3 of for the first 1/3. And the second part, maybe the larger part, we will also try to obtain from the participants what they would like to see in addition to what is already being proposed as by way of amendments to the code, by way of amendments to the regulations, even by way of clarification. Okay, sometimes you may not need an amendment, you might just want a clarification. During the discussion, at any time, you can ask any question, make a comment, or seek clarification. Just use the raised hand symbol, I will recognize you. Okay, and we don't have to wait till the end for any questions. We will try to make it as participative as possible. Let us all assume that we're actually sitting in one hall and not just windows on the screen. Okay, having said that, I will take this to the first. Okay, so this is the as to what are the broad objectives behind the proposals that are being discussed or probably even finalized for placing before Parliament. So the first objective is the one which has been there from day one, and that is to complete the insolvency process in as fast as possible. Really speaking, the code actually envisages the whole thing to be done by 180 days. The 90 days is an extension supposedly only to be triggered for exceptional circumstances. Then came another 60 days for legal issues. So now we are 330. What has happened is that 330 is has become the default. 330 is to banta hi hai. And then we have innovative stratagems like exclusion. Okay, so the period exclude this period, exclude that period, on a variety of reasons. Many times valid, sometimes even frivolous. Okay, or even I would go to the extent of saying managed to extend the process by one party or the other in the entire process. So the first objective is, of course, reducing time for admission. Now, admission itself is a serious case, something which was envisaged to be only 14 days. and as a summary process has now translated into something like a civil court normal adversarial proceeding, where there are arguments, counter arguments, hearings, etc., etc. So how that can be done? So that is again a reiteration of an initial objective for admission. Second is for approval of the resolution plan itself. Now, while admission taking time may not necessarily be as damaging, you know, but approval of resolution plan can actually lead to substantial erosion of value. Okay, during the period when it's in limbo, like plan approved by COC, submitted to the adjudicating authority, but doesn't get approved for a variety of reasons. We'll assume that all those reasons are obviously genuine. Now, one of the reasons besides the infrastructure constraints of and resources constraints of the adjudicating authority, which we all know of, is the number of litigations that are filed by or initiated by so many parties, those with a direct interest in the process, those who think they have a direct interest, and those who really don't have but manage to derail the process by initiating such litigations. So that is objective number one. The second is ways of quickly establishing a payment default. Now, how do you prove that the default has happened? And what is the evidence required to prove also that it is not in dispute when it's a question of a Section 9 application? And there it's a real serious one, because almost every Section 9 application, the first defense of the borrower is that it is a disputed debt. Okay. Whether they have any evidence to prove that or not, but that too takes time. So how do you establish that quickly? What is the ways which can be done by way of amendment in the code or regulations to establish a payment default? The third relates to cross-border insolvency, in the sense that now more and more with globalization, even Indian companies have foreign customers, they have foreign creditors, and vice versa. Okay, there are international companies which have establishments in India, and they could have, center of main business elsewhere. So how do you have a framework which recognizes all the peculiarities of a cross-border insolvency and takes that into account and provides a framework for their participation in the Indian insolvency resolution process? The fourth objective is to maximize recoveries from avoidance transaction. Okay, first is recovery itself, which has question mark, and then maximizing it. How can that be done? We do know that avoidance transactions by their very nature are complex, take time to get established, and take even longer time to recover. So what can be done if there are issues with the law as it stands? How can that be tweaked to maximize this? The fifth objective is steps to enforce a code of conduct for creditors. Okay. There is a code of conduct for the IPs. Today, there is a code of conduct separately for the valuers. But there is no real code of conduct that anyone is aware of for the people who man the committee of creditors and ultimately are the real decision-making authorities in the entire process. And there have been demands of that as on various counts, that the committee of creditors should also be bound by a particular code. So these are broadly the 5 objectives which are attempted to be solved by certain tweaks and modifications in the laws. So now we will take it one by one, and this is a stage where please, butt in whenever you want to say something, comment on that or elaborate it, even share an experience of how any of these issues has affected a case where you are involved in one way or the other. Please do that. Okay, so the first objective, reducing time for admission of insolvency or liquidation or a bankruptcy application for personal guarantors. Okay. Now, how is that to be done? Now, we know that the code has said it, admission should be in 14 days. It never was. Not even a single case has ever happened in 14 days. Uh, it has become like at least 14 weeks now, if not more. Now, can prescribing the time by way of a tweak in the law when it is already there, will it work? And what do you think are the root causes of delays? Because unless we know what causes something, it's like a doctor. I mean, you can't give medicine without knowing what the disease is or what are the causes of the disease. And if that is not removed, nothing that is done will ever have a cure. So this, okay, now this question is open to the House. Whatever you want to interact on. Yes, please. We are waiting to hear from you. This is supposed to be an interactive session. Otherwise, we don't need to add. And then don't look at it as only a means of getting CPRs when you're falling short. That is not the objective. Okay. Look at that as an add-on, but the real thing is that we learn from each other as to what the real issues are. So the first is that just prescribing time, is it going to work? If yes, how? If not, why not?
Raviji, I think prescribing time will not work because the courts themselves have sort of, I mean, the fact that they have said that it is not mandatory and not that any change in timing is going to make it all, mandatory for them. It will continue to remain. That's how they work. That's how it will always be. I don't think it's going to make any difference, even if you decrease time.
Okay, that is the current state of affairs that you have said. Yes, prescribing time will not work, but the query B is more important. What is the real cause of all the delays? Not one, okay, it could be a list of causes. Yes, Anjali ji.
Something which may be politically, but you see, insolvency applications as civil cases, that seems to be the order of the day. So what we've seen is all kinds of applications are entertained. Many opportunities are granted to file all kinds of affidavits, rejoinders, applications, this, that, and the other. I think a renewed look needs to be taken at the orientation. When it is your objective, when it is your brief to delay, you will delay. The bench has to be very strong. So I think that is one of the things that can be looked at. That seems to be a large cause and it can be looked at. And prescribing time, if I may just say, that will again be taken as directory. It is very likely that that will be construed as directory. So I don't know whether that will work.
Right. So you are saying that it's not the law itself, it is how it is administered that's the problem.
Yes, the implementation.
And myself cannot be changed by fiat. Behavior cannot be changed by fiat. Okay. Yes, Mr. Ji.
Yes, from my side. So far as I think from IRP or RP angle, we used to follow the guidelines, particularly from the day when we have to publish advertisement, newspapers, etc. We used to try. But initially what we have found that from the date of filing application by any of the either under section 9 or 7 or so, but as per law, it has to be a case either may be admitted or not, is to take not more than 14 days. So delay starts from that angle. And at that, accordingly, after some time, when case takes 1 year or 6 months or more than or less than that, then RP, okay, used to do things in a manner whatever prescribed by the code. But in anywhere in the back of the mind, it remains that when it has been taken as 6 months, so I also used to take so many care. And if time happens and so many courts has told that it is not, means it is only indicative one. So that is that culture, I think, is the basic reason for all these delays. And what I observed from RP side, In case it goes 180 days, we have to file for 90 days again. In case it goes to 270, we used to file for 330 days. So from RP angle or otherwise, we have to be, means we are compliant of the law and sections. But whereas it goes to the court, filing so many IAS by corporate debtor, otherwise are the things. And from IRP or RP side, what I observed that the delay in taking up the document and charge, etc., are the things which for which IPI found responsible as a myself event, because in some of the cases we are unable to take the charge, and with the 7 days or 14 days or so, it has taken a long time, though there may be so many reasons. So I think yes, for IP and RP, we have to follow the guidelines, and we have been to some extent complying with also. But from AA side, I'm sorry to say, I have told this different forum also, things start from day one. Whether case has to be admitted within 14 days, it is means any case. I have not seen even a single case which could have been at least ideally admitted in a 14 days. So this is the day one, it starts delays. And not ordinary. It is totally means as per nowadays, the 14 days guideline is a ridiculous one. Not even a single case, as per my knowledge, has been accepted within 14 days. So I think either this code has to be make it a practically, means whatever practically possible. If none of the case in India has been admitted in 14 days, we have to do introspection. And as per my perception, these days has to be changed. Means to considering the practical part of the thing. That is my point.
Right. Yes, Mr. Grover.
Raviji, I think the answer to the question has to eventually be to have a checklist, and that checklist will be verified by an IP first, and then he will go through all the documentation and make his recommendation, as we probably do in PPIRP. And that NCLT AA need not go beyond the checklist and stop entertaining other things. And if everything falls through the checklist, then it should be more or less automated from there on.
Okay, just as a response, as a food for thought, the same job can be done by the registry. Why IP? IP might bring in conflict, because IP would becomes an interested party. Registry can very well do that, right? Acceptable, all tick marks. If the tick, if we are talking of a suggestion that these are the things that need to be mandatorily there in the application, they are all there. Verification of debt by way of, there is another provision about how debt can be verified, default can be verified. Then even registry can accept. Some jurisdictions have that automatic admission of the process without going through a judicial part, just at the administrative stage. Yes, but well taken. Some method which lessens the burden of the judiciary and puts them free for deciding judicial matters and not administrative. Yeah.
And we should get rid of the timeline. Let it not be 14 or 1400 days or 14 months. Let the timeline go away. We just have a checklist. Either with the reason I say IP is because it's not just a matter of collating all documents, ensuring all the documents are in place, but somebody need to go through it, and maybe just in another layer of having gone through the documents, and then recommendation from the IP would just make it a little easier. So yes, all the three. I mean, registry need to collect.
Somebody has to do that. Yes. Any other viewpoint?
Sir, I differ for no timeline. There can be a maximum cap. Suppose say 6 months or 9 months, whatever be that. But no timeline would be again the same thing happening.
Okay. What emerges out is that first of all, 14 days probably is ridiculously low and unachievable, unless the whole process changes from a quasi-judicial process to a summary administrative process for the admission part. Okay, I'm not talking of after that. If that happens, that's different. Otherwise, if it does go as a quasi-judicial process, then we have to take into account that we are obviously none of us is saying that judges or members are sitting idle, right? They are not. We can see them there from morning to evening. They are sitting in the bench. And when do they find time to understand all the issues that have been argued before, then find time to go through the pleadings because what is said in court is only a small part of that, and find time to dictate an order and get it issued. Okay. So these are the things that basically are happening beyond normal working hours. So, okay. So that is one. And if you look at the entire justice administration system in the country, with all its faults, IBC is still the fastest. So one can imagine what the others are like. Okay. But what is the root cause? We have not yet gone. So one I understood from the responses is to treat it as an adversarial process rather than a summary process. And accordingly, evidence, counter evidence, submission, written submission, reply, rejoinder, sir rejoinder, all that is happening, and that would definitely be cut out. So how do we do that? Actually, there is a separate proposal for that. But if unless somebody else has a different opinion, one thing seems to be clear: prescribing a timeline, writing it on the wall does not make things happen, right? Whether it is written in the code or in the regulation, it's not going to change anything unless the root causes are dealt with. Okay. We'll go to the next one now. Okay. This is again about timelines. Now here we are talking of approval of or rejection of a resolution plan. Again, similar issues, root cause of delays, just prescribing that so much time it has to be done. Will that work? What happens if any timeline is prescribed and that is breached? Forget mandatory directory is an issue by itself, but if it is breached, can one say that if the adjudicating authority does not approve a resolution plan by so and so date, it shall be treated as rejected? That would be penalizing somebody for not their fault. So it can't be done. And how does one get over this mandatory versus directory? Because this is, I would go to the extent of saying this is a part of the basic structure of our legal system, that timelines are mandatory for the implementer, but always directory as far as the judiciary is concerned. In any law, it doesn't matter which law. It's always, that's the stand that Supreme Court has consistently taken, that timelines cannot be mandatory for judiciary. So how do we deal with that? I think the answers are similar to the first one. So we will proceed from that to the next one. That wherever it comes to fixing of timeline by prescription, unlikely that anything really will happen. They can keep on fixing timelines, but it won't happen unless there is a where not doing something does not result in a penalty of some sort. It will always be stretched. That's like fundamental. And courts have also ruled consistently, you can't penalize somebody when there is no penalty prescribed. And in this case, whom do you penalize? Okay. A solution partly is this proposal, which talks of ways of quickly establishing payment default. That for certain specified prescribed category of financial creditors to begin with, the proposal is that if the IU certificate shows a default, it is a default, no more arguments, no replies, rejoinders, nothing. Story ends. A certificate from the IU showing evidence of default is conclusive evidence for admission of the application, unless there is some other reason besides that. Okay, so this is the proposal. There are certain issues with this, or rather one primary issue relating to fallout from that. And that is that today the IU is a monopoly situation. It's just one. And while financial creditors being institutions and basically largely dealing with public money, so they are probably, they can by fiat be told that all your credit data should be part of the IU, file everything and include reporting of default as and when it happens, etc. What happens to smaller creditors? Now, whether the charges that are being currently levied, are they reasonable for the service that a single IU is performing? And okay, slightly moving away from the specific question here, that the charges that they levy or they prescribe for IP related services like the PDA or even taking up certain storage space on their portal, are they competitive enough, or is a monopoly situation being maybe misused or taken advantage of? Okay, misuse might be a strong word, but taken advantage of. But the primary question is, the proposal is that one relies on the IU for at least certain category of FCs to start with, so that part of it we were just discussing, reply, rejoinder, dispute raising, etc. That all goes away, simple, because the certificate of the IU is considered as conclusive evidence. Do you see any problem with this proposal? Could it be, can the cure be worse than the disease? Let's hear from somebody else, unless everybody else is only logged in but not present. We are going to take a mid session attendance with video on.
So the way I see it here is that, of course, IU is a monopoly situation, and the fees being charged presently is substantially lower in my view. And knowing that the kind of expenses involved in making this software and all are pretty high, they will be increasing it. They should eventually end up increasing, which them being a monopoly will continue to be a problem. Them being used for a specific type of creditors, banks and all, and for that group, yes, it is something that can be done. Can't be made mandatory. There are so many people I know, they get letters from NESL asking them to verify, and they don't bother to reply. So, and they say that if you don't reply, we'll put a red flag, which means effectively you're done, and which is obviously going to be a problem. And again, it will be the AA will not really, they will carve out an exception in this case as well. So, but it's a good idea to begin it for a specific group of creditors, bankers, and of course we need, at least one more IU.
Any other comment or question?
Yes, sir. BK Mishra, yeah. Sir, so far as IU is concerned, yeah, I have also came across the one IU, which is NESL now. So yes, it is a monopoly type situation, because they are only little able to do. And in case, so far as fees is concerned, because time as well as the money which is involved in making an application, waiting for so many times, and advocates, etc., the fee which is still being charged is, I find it very adequate. And yes, tomorrow, in case they will increase their cost and other things, it may certainly go up. But by now, if they are well equipped, and by now, I think after 5 years of introduction of this IBC, they are in a position to respond to the financial creditors in the form of concrete information to be placed before the A for expediting the case. That is my point.
Yes. Anybody from their experience, those who are practicing, chartered accountants or company secretaries, etc., any of your clients, non-FC clients, have they taken the benefit of this facility of putting up their, receivables onto the IU, including informing of default? And if so, what has been their experience? And if not, why not? Anybody has any idea? I'm sure you would have, many of you would have clients who are.
They do receive mails. This is Saurabh Javeri, practicing company secretary. My clients do receive mails on charges getting created, but there is still a lack of awareness, or there is some skepticism for getting their charges registered on the information duty.
No, not just charge. I think you can register your debt.
Yeah.
IO is not for registration of charge. It is
Right.
registration of debt and default only.
Right, sir.
Charge is either ROC or CERSAI.
Absolutely. But there is a confusion. I mean, they are not much clear. They do ask us.
And what do you say? Now, this is exactly what I was coming to. What do you people say? Do you recommend yes, no?
Yes, we do.
Or you say, I don't know.
So, yeah, initially, to be very honest, I have not gone that much into it, but I do tell them that there are always a number given, contact person details. So I do tell them to first verify what exactly the requirements are, and I try to guide them. But honestly, till date, I have not taken much interest into that.
Okay. Anybody else can share any experience of any of their clients? Okay. Right. So if nothing else, we will move forward. From what I can assess, I think just 5 people are present. Others are only logged in. Okay. Before we proceed further, I just want to make a mention of this because this is an evil which is becoming worse day by day. It's like a disease where IPs, okay, we belong to the IP community. We find fault with everybody for whatever they do or do not do. But we do not even have the common courtesy of that you have signed on for a program. The guidelines say that you have to be present. In fact, they say that your video should be on all the time. Otherwise, you will not get CPRs. And we flout it with impunity. Absolutely. And you take, as I said, I think 65 is the number I see. Excluding officials, it will be 63 or 62. Out of that, just 3 or 4 actually appear to be present. The rest are logging in. So, there is this old parable from Bible, Pehla Patthar Kaun Mare. So before we, start haranguing and giving gyan to all and sundry, thoda apne andar bhi jhaak kar dekh le ki whether are we even looking at the mirror? Okay. If we can't do this simple thing right, then what is the guarantee that we can do other things right? And like we say about litigation, some of the lawyers who are present here, maybe you can share your observations on this. Of all the litigations that are filed during an entire CRP or liquidation process, IS, okay? When we say litigation, we will talk of the different IS. What percentage are filed by the IPs? The IRP, RP, or liquidator?
In my experience, sir, I think it is 90%. In most of my cases, 90% of the IAs, they have been filed by the IPs. And most of them get disposed of if there is any settlement. After a period of 2 years, 3 years, there have been instances when the appeals have been allowed, appeals of series have been allowed, and all those IAs, I would say 15, 20, 25, or whatever number is pending, majorly filed by IPs, at their cost, in most of the cases, they get disposed of. So the purpose, or that's what I have experienced in some of my cases.
Okay, the follow-up question arising from this, IA in an IA, like sometimes we do that. Okay.
So my view
Of-
is quite different.
Yeah, okay, Bully.
What I see is there is a lot being filed by persons and entities other than IPs, creditors, directors whose powers have been suspended. You see, all kinds of interested parties, stakeholders, but a lot of it is litigation, which I would say actually detracts from expeditious CIRP and the process concluding easily. So that's what I meant, when I said initially, uh, uh, and the benches entertain it. You see, there is also this thing about rules of natural justice and how you have to, that happens in civil courts. The adversary has to be heard. You use the right term when you said summary and not adversarial. So basically what is happening is that it seems largely adversarial. And I would say, of course, IPs and liquidators do file, what they are mandated to file. But there is so much else that is being filed by creditors, resolution applicants, rejected resolution applicants, directors. A lot of litigation, a lot of time and space is taken up by this kind of litigation. So I would say that a large part of what is filed is by persons other than IPs and liquidators. That is my experience.
Okay, so we have both sides. So the truth as usual lies somewhere in between.
In between, maybe, yes.
But my next follow-up question, of all the IAs filed by IPs, see, we can't do much about other people, right? So let us restrict ourselves to what we can do about, that is ourselves, always. So any human being can only be sure of his or her own actions, not somebody else's. So now the follow-up thing is that of the various IAs filed by IPs, excluding the standard ones for extension or exclusion, I mean, those are mandated IP or filing for approval of a plan. The code and regulations together really talk of 3 or 4 instances where an IA necessarily needs to be filed by an IP, not beyond that. Now, here's an example. Okay, there is some claim which is rejected by the IRP or RP. Okay, the aggrieved party goes to NCLT. NCLT makes an order, you have to accept this claim. Okay, with me so far? Now, the IP goes in appeal. Sometimes all of the way up to Supreme Court. Sometimes, not always, but sometimes. The question is simple. How is the IP an interested party? Another creditor might file that, who is aggrieved by this inclusion. Okay, I am a secured financial creditor, let us say, for simplicity's sake, and another party whose claim was rejected on certain grounds, got admitted because of the because they went in before the NCLT. Now, I as a secured creditor could have a reason to say, no, your claim should not be admitted because I will get less. Okay, aggrieved party. Now, whether A gets or B gets or whoever gets more or does not get, how is the IRP or RP or a liquidator concerned? Where is his interest arising? Where is his locus coming to file against? Because effectively, the IP's boss effectively is the NCLT. So if you are in a working situation and something like this, the boss gives a decision, do you go in appeal elsewhere? Will it even be entertained? That is being entertained. Now, IAs in appeal, especially in appeal, filed by IPs who have no locus whatsoever in such issues, or who are filing this on issues which have already been decided, sometimes as high as the Supreme Court itself on certain issues. You will keep hearing this again and again. Just as an example, I'll tell you, Provident Fund priority of dues. You just scan any of the law sites and see how many cases are there. When it has been upheld by Supreme Court itself, what is it and what is not. And who are all the people filing? Okay, the department files. Why does it file? Because you say no. Why are you saying no? Because you feel like it. So coming back to that, to the extent that we contribute to the delay, let us at least start doing something about it. Okay, having said that, let us look at the next point. Okay.
Could it be that the IP is being forced by the other creditors to hold back the claims of certain creditors for whatever reason? And
though if the IP is so weak as to be forced to do that, doesn't deserve to be IP in the first place. Okay, IP is a position as CMD equivalent. अगर आप इतना भी नहीं कर सकते तो क्यों है वहां? Be out.
you have to go against the banks.
Yeah, that, see, the whole point of a neutral administrator is you should have the guts to go against if required. At that time, if your own commercial wisdom comes in the way, then there is a serious problem.
But the whole infrastructure, the whole system is poised in or has been.
Now we start getting into the TV debates, the larger issue. Like, we can't do anything about the system, right? We are individuals. All we can do is about ourselves, each one individually, not the IP community as a whole. No, I as an IP, what can I do to make things a little better? All the grains of sand will one day make a beach. Okay, if we do that much. Yeah. So now we are talking of maximizing recoveries from avoidance transactions. So one of the proposals is to amend the look back period from what it is. It's now talks of 2 years or 1 year from the date of admission of the CRP process. The proposal is to make it that trigger date to be the date on which the application is filed, so that all the transactions which happen during that period to get caught in that, and not, the 2 year period. Suppose the application itself to get, as we know very well, takes about 1.5 years, 2 years to get admitted. So the look back period then comes when the application is already filed and maybe the damage has already been done much before. So this is talking of the trigger date being the date on which an application is filed. So every action and every transaction that happened during the 1 year or 2 year period from that date, look back, will fall within the grip of the avoidance transactions. Taking our delay period into account, this obviously will help. Okay, it will cover a much longer period than what otherwise would have been covered. And as in most cases, we know, maybe not much to find in that period. But the question that comes out is this the real issue? Is just making the look back period longer going to help in getting better results in terms of getting enough evidence to be adjudicated in the favor of the application? Is that enough? Just look back period, is that the problem? Or is it that getting evidence is the real issue? And if evidence is the issue, then is the IP, however competent otherwise, does the IP have that much bandwidth and resources and even knowledge to be able to collect that degree of evidence which will stand in a court of law? Because now avoidance transactions, the proof threshold for admission will be much, much higher than admission of an insolvency. It's almost criminal in nature. So it will be beyond reasonable doubt, will become the norm. Not preponderance of evidence, not even single piece of evidence. So just look back period, does it? This is my view. Okay. Any differing views will just look back period help? Firstly, in accepting that there is an avoidance transaction based on the application filed by the IP concerned. And second part, of course, after accepting it, how do you recover that? Okay. Yes, any views?
It will help.
It will
It
help.
Okay,
will
how?
help. You see, it'll take more, as you said, it'll take more within its gambit.
A
Most
longer
likely,
period, yes.
yes. You see, because obtaining relevant evidence is not something that can ever be uniform, as in some may be able to do better than some others. So, whereas that is also an aspect to be focused on, that is it. This is, this is something which will add to value, so to say, a larger look back period. Of course, it does come to obtaining relevant evidence also, but that will always be something which is not uniform. Some will get more than some others will. You see, it depends on effort, ability, many things.
Yeah,
So my view is it will help.
generally, yes. We will always say that results depend on efforts and competence in that. That's true for every action, in life,
Yes.
whatever you do. But knowing the situation in our country, especially when a company
Yes.
goes into a CIRP application stage, usually it would have traveled maybe BIFR, SARFACE in most cases, okay, and years of that, definitely NPA, barring a few exceptions, which are pressure cases. But the significant number of cases that are still there, because we have a lot of backlog, are those where the like we said, the haircut happened long ago. We just have to recognize it. We have not looked at it. That's all. So, but how do we address the issue of getting evidence? I mean, this is not an answer which we can get in today's session, but a real problem, because it's not an Indian issue too. I was just looking at some article of how it happens in the UK, which has had a far more longer period of experience, 30 odd years of insolvency law, on which largely our law is modeled. And it said that in the preponderance of cases, recoveries are abysmal, almost non-existent. And at best, if it has happened by way of settlement or some sort of thing, where it's a negotiated thing between the person who is found to be guilty of that transaction and the IP committee of creditors, whatever. Because if it goes to court, and see, the moment the order is passed, recover this, after that it becomes like a proceeding before a civil or a court of a recovery. And we know how long that takes in this country. So how, and that question still, it's there out, it's not, there are no easy answers to that. But also a reason why recoveries are low, almost insignificant, I would say, maybe 2-3 cases, probably 5, where something has been recovered in all these 5 years, which is an average of 1 per year, and likely to continue to be a problem. Because just look back period it will expand your ambit of the IP, of what he can. And those who have been, let's say, not intelligent enough could get caught in that net. But maybe not. Okay. So next one is that provision of continuation of avoidance proceedings even after approval of a resolution plan. Now this is there in the regulation, right? It got amended. And I think the order which came out yesterday, Winners Recruiters, refers a lot to that part, as to that was always the intent, that avoidance transactions should continue to be pursued even after the approval of a resolution plan. The question stands still today: who does it? Who will do it? Who can do it? Who ought to do it and who ought not to do it? I mean, a lot of questions come up. The High Court judgment in Winners Recruiters, the which was in appeal by the division bench. That says the RP can, because they distinguished the entire process as CIRP, the basic CIRP process, where the RP becomes functus officio after the conclusion of, after the approval of the plan. But the avoidance transactions is a separate part and not linked with that, and the RP can continue. And there is comment on remuneration and who shall decide it and all that. What is your opinion? Who should continue? Who is in, let's put it this way, not who should continue. Who is best placed to take it to a more successful conclusion among all the people who can continue it? Okay, there are three options broadly. RP, okay, COC, or members of the COC who stand to benefit. The third is the board, IBBA. Okay. These are broadly the three options of who can continue. This is part of the discussion paper of IBBA itself. They also mention these three and how the costs, etc., will come up. So what is your sense? What of people here, participants, who is best placed to continue that in terms of the better rate of success?
See, primarily those who stand to gain, which is the COC, which is the creditors, yeah, COC.
Self-interest.
Self-interest.
The biggest motivator of all.
That
Yes.
is, that goes beyond doubt. I mean, IP has no interest, IBBA has no interest. Only the ones who have interest are, I mean, if you give it to the RA, then maybe he's interested, but then that is not the case here. So it has to be COC, and
So there is no bar on the RA being a beneficiary. Yeah? Let's be very clear of that. Because except that it has to be upfront and part of the plan saying, I will pursue it, I will get the benefit of that. And I save you from all this litigation cost associated with it. It may come, it may not come. I'm giving you this price. That's a perfectly valid legal contract. Okay. It doesn't violate any law. If not, the problem there in Venus was it was not mentioned who will get the benefit. And suddenly the CD said, I mean, the RA said, I want to take the benefit. And court said, no, sorry. You bought it at this price. This is what you offered. You never factored this in. Now you can't get unjust enrichment. So take that aside. Let's say both options are open. But still, like, who is in the best, who is likely to be most successful? Darwin's theory, self-interest over all else, right? जिसको मिलेगा वही तो अच्छा काम करेगा ना. And we talk of this in all walks of life. If there is incentive, we work better. Large. Okay.
So if it's the RA and if he's mentioned it in the plan, then obviously he gets to follow it up. Otherwise, if COC is interested, but there could also be a situation where the CD and COC sort of, I mean, a remote chance, but COC also may not be interested for whatever reason, and yet it should be followed for national interest and other reasons. In which case, maybe as a last resort, IP with IBBI should also step in case it reaches that level, because it may not necessarily be a matter of self-interest all the time. It could be national interest. Which
any other view on COC being the right party to follow or not follow? Yes, Karunaji, you wanted to say.
Yeah, I think COC would be the right party. IBBI may take, notice of its suo moto, but what would be the mechanism in that case? RP, I would say, is certainly not in the position to do that. IP is a professional. Once the resolution plan is, approved and implemented, and there is monitoring committee or whatever, once that is done, as a professional, IP is, I don't think, is connected or having the should be looking into it once it is all done. The IP's role is done once the monitoring committee and that part is cooling down period or whatever terminology is used is finished. IP's role is finished, I believe in that. And unless there is a trigger, ultimately it should be informed to the IBBI, and IBBI should be taking note of that. and taking, action or doing investigation or whatever should be taking care of that. COC, yes, they are the interested party. If at all they are in that matter, major creditor or something, they should, take cognizance of that and should file appropriate application or should bring it to the notice of IPBI, and then it should move on. That's my view on that.
Right.
Maybe
Any other
it should be
comment?
the,
Yeah.
maybe it should be the two together. That is, COC leads it. But I think an IBBI role in this kind of thing is also required. I think
Okay.
there has to be some regulation and some overlooking, so to say. You see, like Atulji just said, it is also, I mean, there is an element of national interest also. You see, you have to have the right kind of recoveries. I mean, if you
Right.
see the broad objective of the law, so maybe it can be the two together in this manner.
And maybe it can be that if the creditors don't follow it up and IBBI does it, all the money goes to IBBI.
Yes, why not?
It
Why
should.
not?
It should. I mean,
Yes, indeed.
Consolidated Fund of India, it goes to
I
That
the
think
would
we-
be
Yes,
a
we-
motivation,
indeed.
motivating factor.
kuch to milna. I mean, there has to be some incentive for the party. I mean, party even
Absolutely.
in a representative capacity.
Exactly.
In this case, for the nation. Yeah. So if the COC doesn't take it up, it will go there. But okay. Now I have just off again a little off the beaten path suggestion. In every situation where the COC refuses to take that case forward, I think report should go to RBI. They don't want to take this forward. After that, you do whatever you want.
I think that's an excellent idea, an excellent suggestion. That
See,
furthers national interest.
Yes, in general, we are afraid of our boss. We are not afraid of somebody else's boss. Okay, the boss of most COC is always RBI. In most cases, 99% case, 99.99 by value. Okay, so we know if RBI कहता है तो सब मानते हैं. At least the creditors would, because they are governed by. Okay. Sorry. Okay, so look back period, we looked at continuation of awarded proceedings, who can do it, and general consensus seems to be that the persons with the interest should do it. And if not, if there is no such person available, then IBBI or any other agency which the government deems fit could take it forward. It could be MCA, it need not be IBBI, it could be MCA. Maybe they have more resources and more reach in terms of taking, and more experience, because there is a whole inspection wing of the MCA which does this kind of job when it is not in insolvency. They are supposed to be trained for that. And they are also the nodal ministry for the NCLT. So probably they will have more, they'll be heard more than anybody else. And C, give creditors power to apply to AA to investigate avoidance transaction. This is there basically if the IP fails to do so. Obviously, because if it is already filed by IP, then it's not duplication. It's talking of situations where creditors can directly file, not just 66, but others too. Today, the code allows only one category of avoidance transaction where the creditors can take action to initiate avoidance proceedings. But to cover all of them, that if the IP doesn't do or is not in a position to do for a variety of reasons, lack of information being a very important one, cost associated with it, cooperation of the people, time required. I mean, these are very complex proceedings, and the Venus Recruiter Division Bench judgment actually recognizes this very beautifully. It talks of the complexity, why it takes long, etc., and hence requires time and resources which an IP may not be having most of the time. So give creditors to power. So I think, again, one of the welcome suggestions, no doubt, and proposals, I would say. Okay, so we next come to cross-border. Frankly, I would say not much to talk about. These are enabling provisions which generally are there in the, and they are basically part of the UNCITRAL model law on cross-border insolvency. The proposal is to adopt that law. It has two distinct advantages. One, we don't need to rewrite the law, reinvent the wheel, so to say. It's been done jointly by experts across the world. Whatever tweaking they need to do, minor for the Indian condition. But it also makes, it has got a principle of reciprocity. That means that two countries which have adopted the model law, then automatically recognition of foreign proceedings happens because of that. And those which we have not, such countries will have a problem, either pursuing something in a foreign jurisdiction or allowing a foreign creditor or somebody to pursue something here. Okay. Has happened in a way recently in Jet Airways situation. But this is a proposal that early handover of assets to winning bidder, even before the distribution of money starts. So, okay, A, B, C, D are the flags that I have raised. Okay, what about acceptance of such a provision by creditors? Don't they have to agree that they will do so? Okay, to protect their own interest. How will their payments be protected if it is handover is done? What are the mechanisms that can be put in place and are commercially feasible? See, one can very well say, okay, give me a bank guarantee for the entire amount that you are going to pay. If that amount is 500 crore or 1,000 crore, large amounts, how will that such a person get such guarantees? And even smaller ones, it's not easy. Then what are the real reasons for delays in handing over control now? Okay. So C is where share your experience. What are the reasons for delay in handing over control today? Appeal and stay order from NCLAT, let's put it aside. That is judicial intervention. Other than that, okay, I'll share something with you. Very funny story. It's laughable, but it happens. After the and this happened, I think, in 3 cases. After the resolution plan is approved, and then the plan had a clause which said definitive agreements, the detailed agreements which put that operationalize the plan, that will be entered into subsequent to the approval of the plan. Now that part, which talked of basically sharing of charge with the incoming RA, one of the partners of the consortium, issuing of debentures as one of the instruments, etc. Now this entire thing took about 8 or 9 months. Now the joke is not this, that it took 8-9 months. The RA was same in 2 other cases. Most of the creditors were same in those 2 other cases. And they went through every part of the procedure, including vetting each document, which was identical, copy-paste, except for change of names. In all cases, by appointing a legal firm for vetting separately. Until such time, control cannot be given. Obviously, because those are essential conditions of the plan. And then comes, of course, the distribution of money part. If the plan says that the money will be paid by so and so date, but control will be given by an earlier date, should not be a problem, which is part of the contract. But if it is the other way around, how can such a proposal be just or even legal for that matter? Yes. Anything to say? Do you find this proposal okay? For background, just refer to the recent order in Jet Airways. There may be other issues with, but Apparently, it was that payment as promised was not given. They sought more time. That time was given, control was handed over. Now, something which is commercial in nature, right? This is a commercial part, right? You pay me, I give you control of this asset. Can any other body, parliament, executive, judiciary, decide otherwise and say, no, no, aap de do? So who takes responsibility of that default and the cost of that default? Maybe COC has all its problems over the last, whatever it is. But we can't look at that, no? क्या लगता है? Looks okay, doesn't look okay. Serious issues or no? De dena chahiye. In the interest of maximization of value of assets. God alone knows. I never understood what that term means. Because I was taught in operations research that the concept of maximization does not exist in nature. Period. There is optimization, which takes into account constraints. Maximization is called open-ended. वो होता नहीं है. But everybody talks about it. Nobody understands it. Maximization is within a set of boundary conditions. What is that maximum for me would be probably the starting point for somebody who is a billionaire. Yes. कोई बोलता ही नहीं है. Same people. Yeah, I think same issue.
I think, I'm sorry, I'm
Yeah,
driving.
can you just introduce yourself, because iPhone is
Sir.
not a human being.
Yeah. This is Atul Grover again. I just happened to step out. So.
Okay. Yeah. बोलिए.
देखिए, जहां तक obviously you can't give control unless the payments have gone through, and I believe all these things would have been detailed out in the resolution plan. And when will the control be handed over? When will the payment be made? And if the control is given and payment is defaulted, then definitely who's going to be responsible? And we know very well that if in a situation like this, it can continue in courts for years. A normal check bounce takes whatever. So it's definitely wrong, and I think what happened in Jet Airways should probably be an exception only. I mean, that's so far as the handing over control is concerned, unless there are other reasons. I mean, that's all I have to. I mean, there's nothing else I can say about it. Yeah. It should be very clearly mentioned in the resolution plan, and resolution plan contract should be followed to the letter, and any violation of the resolution plan should be very summarily be taken up and resolved.
By the way, I don't know if how many have noticed this, that the code does not provide any penalty for any default by the resolution applicant. It does not. If you look at the section which deals with, failure of a resolution plan, it doesn't say resolution applicant. It says corporate debtor. The RA becomes the CD only after takeover. Till such time, it's a separate entity, but no provision is there in the code. So there is a gap. So that's why people can get away with a lot of things. So many people who have given plans, became successful, so-called SRAs, and have not actually fulfilled their mandate. COVID has been a reason which has been given for anything and everything. And probably for the next 5 years, people will be talking of COVID. Okay, so we will go to the next one. We have some consensus on this, that there is an issue, but one caveat here. This proposal is as culled from the media reports. It may not actually be true, or it may not be what we understand it. Could be something different. Maybe they are dealing with some other situations of handover and not violation of the plan per se.
See, a resolution applicant will never write in the resolution plan as to what should be his punishment in case he violates. So that has to come, that has to be put in some kind of regulation, and it has to come as a part of law of some sorts, which has to be thought through, so that you know, the resolution plan or the system is not scammed. IBC is not. Yeah.
Yes. I believe this issue was flagged during a meeting with the minister, and where members of the adjudicating authority, AT, were present. And apparently most of them got taken aback. Huh? Aisa hai kya? You know. So, hota hai. India hai, kuch bhi hota hai.
Yeah.
I think, myself, Vijay Mishra, in my opinion, all the resolution plan, I think it should be, and it is the responsibility of all these COC and others, that while getting 29A or other things, there should be a provision. That means must be a provision that in case of any failure on the part of this RA turned corporate debtor, failure means on account of payment or another way, there should be a clause that how can they be penalized or how can they can be exited from the entire this plan. That should be there, and there should be a template which must be kept compulsory, either by IBBI or otherwise. IBBI, I think, is the right body for that purpose.
No, IBBI, first of all, does not have the authority to levy penalty on anybody. Okay. The regulator of such people who flout such things, they may have that power, maybe RBI, but IBBI cannot. It can come in the court, yes, because that's Parliament. Parliament has that power to prescribe penalties for, you know, defaults on the part of an RA. The resolution plans do provide for performance bank guarantee, yes.
Certainly.
But
Yes.
the real problem is no creditor or COC wants to encash immediately, because they are accustomed to letting a problem go beyond recovery before they start the first step. So आदत है.
Yes, yes.
70 साल में नहीं किया, you know, the leopard is asked to change its spots.
Because sir, here the biggest loser is the COC. So COC has to take call and save their interest.
Yeah, one of the things that can happen is IBBI itself cannot impose penalty, but it can, in that regulation 38, if I remember, mandatory conditions of a regulation plan, of a resolution plan, can require that the plan should provide what will be the penalty if there is a default.
Certainly, that should be.
By way of a contract, so it becomes contractual. That
contract,
like so many contracts provide for it. Liquidated damages, bolo, penal interest.
So many things. Yes.
Increase in resolution value, bolo, you know. Okay, we accept it for 100 crores, but if you delay, not only will you pay interest for the delayed period, you might have to pay more, you know, things like that.
Like demurrage and other things, it should be.
Yeah, those are the things. One are safeguards which might help, but any other fiat is not easy. Okay, now real estate. A lot of discussion has taken place over the last 5 years. A very large number of real estate companies have gone into insolvency for maybe a lot of reasons. Whatever it is, we know, all of us know what some of the reasons. The large amount of cash component in the sector, which used to prevail for a long period, and so many other things. Mindless expansion. When money was free, everybody and sundry launched new projects without any idea of how they will complete it. Now they're talking of new rules for handling real estate. There has been a discussion paper from IBBI on this, which basically says that real estate insolvency should be done on a project-wise basis. That means if a corporate debtor has 4 projects under it, which are at different degrees of completion, and not all of them may be in default as far as their allottees are concerned, then what should go into insolvency and what should not? So provide for project-wise insolvency. Then provide for handover of units to allottees even when the insolvency resolution process is ongoing. There is an issue behind this either. And how are the projects, accounts of the project and the developer entity as a whole, how can they be separated for control during the resolution process? So some of the things that are there. When I say project-wise resolution is not new, that is based on the very definition of project, real estate project. Because IBC refers to definition in the RERA, RERD Act. And there each project is an independent thing by itself, irrespective of who its promoter entity is. So is this a good thing to have going forward? The provision for resolving by project, and what about the issues that are flagged? Okay, I think we have got an attendance of 0 now, right? Jo the wo bhi chale gaye. Very nice. Okay. So no response, we will go ahead.
No, the fact I apologize, I'm still driving around, so
Okay, 1 or 2. I am talking of the larger number. 69 as per participants, and not even 10% actually being present. Why 10%? I think 5. Then it's tragic. Of how we look at this entire thing on these sessions. We are actually buying CPRs rather than acquiring them by effort. So
this is Harsh Arora here, sir. I think it is a very useful proposition. It should be project-wise only. Otherwise, what happens is that everybody suffers. For the projects which are advanced stage of completion, the allottees there also suffer. I think it's a very good suggestion and should be done like this only. This is my view.
Yes. And the code actually enables this. Yeah. So these are changes which can come in the regulation itself. Because by definition, code says that insolvency of a real estate project. Actually, it says that. It never said the corporate debtor owning the real estate deal. But there are issues like pooled account. Okay, now all those which are registered under RERA, they have to have a separate account, escrow account type of thing for the particular project.
Right.
But there are other where money has, 30% of the money can still go into the combined account. So how does an RP who has got project A under resolution, but not B, C, and D, take control of that 30% money which is there in the central pool? So there are issues. It's not easy, to say project.
There are issues, but overall the proposition is very welcome proposition.
Right. Okay. So we will proceed to the next one. Now this is about voluntary liquidation. That the proposal is that once the process has started somewhere along the line, maybe the board of the company or the liquidator or both together come to the conclusion that yes, we thought we can do this based on certain estimates or projections or whatever. But now as we go along, we discover that probably we can't actually liquidate voluntarily because the liabilities that we have to square off are more than the value of all the assets that we have or which we are willing to contribute to as promoters. So we would like to withdraw from this process. Now, how do you make that happen? So what the proposal here is to make it the way you came in, the same way you can get out. Okay, how did you come in? You came in by way of a shareholder resolution backed by a board resolution and implementation. So you want to exit from that, follow the same process. Okay, you can yourself decide because it's voluntary. So entry voluntary, but today exit is not. Exit should also be voluntary. So broadly, one can say, yeah, okay, that's how it should be. You thought you could do it, and then you withdrew after some time, saying, okay, now I can't. This is when the board of that company and the shareholders and the liquidator are in sync on the conclusion and what should be done. What if they are not? Where the process itself either has been initiated fraudulently, or after initiating, people don't want to take it forward in terms of defraying cost, providing for that funding for the cost of the process, because they realize, okay, maybe same issue, the value of asset either is not adequate or will not be realized soon enough, or for any other reason, then where does the liquidator go? So if such a voluntary exit is allowed, there should also be a provision for exit where the liquidator can make an application. There have been cases, the discussion paper of IBA, I think, lists about 6 or 7 instances where the NCLTs have allowed the closure of the voluntary liquidation process on an application filed by the liquidator in almost all cases. The issues of fees and expenses remain, wo to permanent problem hai, ho rahega. Okay, I think people have to take care of their own to some extent. Haji, boli.
So there have been cases, in fact, I myself am an IP and have been an advocate as well. So there have been instances when we made applications for withdrawal of voluntary liquidation. The benches were kind enough to allow it, but in one of the cases, they did not allow.
So was there any reason why in a particular case it was not allowed?
So in that particular case, the order was reserved, but apparently when the order came, the corporate person was dissolved. So when we made an application for rectification of the order, we were told that a process has been initiated and there is no specific provision in the code for withdrawal or suspension of voluntary liquidation once commenced. And at a later stage, since the stakeholders agreed to that decision, so we abided by that. But yes, there had been an instance when NCLT did not allow that withdrawal application.
Because two processes overlapped and what should have come later happened first. Okay.
Right.
Ho jata hai. More administrative snafus than anything else.
Absolutely.
And then people will say, okay, we did it. It is like saying I could enter. Oh, abhimanyu ho jata hai. I know how to enter. I don't know how to get out. Yes, can happen. Yeah. Okay, now we come to the favorite provision of all IPs, code of conduct for creditors. We all want it. If we have it, why not them? That's the usual first level argument is that हमारे लिए है तो उनके लिए क्यों नहीं? We do so much, and why should they get away with XYZ acts of commission, omission, whatever you call it? So, is there a need for such a code? First question. And with reason, na mujhe lagta hai is not a reason. I get into problem because my COC has not approved my fees, so hence there should be a code of conduct which forces them to approve fees and expenses is not a reason. Okay. It should be for the broader objectives of IBC and not just individual issues.
Certainly, I am of the view that there has to be a code of conduct for the COC as well. In case there is no such code of conduct, there has to be some legislation is in place which mandates the COC to govern for governing the COCs, because there have been instances in a few matters. Let's say there was a matter in which there was sole financial creditor who was constituting the COC there. So one matter, the fee is of course an important matter, I would say. But apart from that, the process related, I mean, timelines are there in the code and they do not adhere to the timelines. Like for didn't approve for
Please mute yourself. Boli, sir.
COC didn't approve for publication of Form G. They didn't. Of course, it was the IP's responsibility to appoint the RVs. But if there are no funds in the corporate debtor, then COC has to bear it, and the COC has to approve of the fee also. So what they didn't approve of it. And at a later stage, the IP has to make explanations as to why the delays have happened, and you should have taken care of that. So certainly there has to be a legislation in place for the COC to adhere to the timelines for, they need to decide upon matters which are there in the code.
Right. Any other comment or opinion?
Yes, if their commercial decisions, their commercial wisdom is what rules the roost, so to say, then there has to be some, there has to be some accountability. You see, when such a large role, when such a large responsibility is attributed to the COC, there has to be some mechanism for judging whether that is being discharged. And at the very least, there has to be a code of conduct. I mean, what the code of conduct will be, of course, will require a lot of application of mind and by the RBI, of course, but perhaps again, it can be the IBBI and the RBI together. But I think this is the very least that has to be there, because their commercial decisions are what determine how the entire process will unfold. Of course, there is the law, but still so much is left to their commercial decisions and their commercial wisdom.
Right. Okay. Some of the reasons why we talk of primarily, I think the overwhelming reason was approval of fees of IP. Now that has been taken off the slate with the minimum fee in place. Now that is largely not going to be a matter of dispute or litigation. Okay, the minimum largely has now become the maximum. Wahi utna hi milega, unless you can specifically negotiate a higher fee. Okay. Lower is not allowed because it's a mandatory minimum. Now that being away, now what is left is expenses. Now that is obviously nobody can have a law on that as to what shall be the expenses. And the costs of valuers and other professionals to be appointed. Now let us look at, okay, where not private individuals are creditors, but the dominant cases by value and number, which is where banks or financial institutions in one form or the other, whether they are public or private, are involved, including ARCs. Of all the cases that have come and got reported at a later stage, either through IBBI DC proceedings or through NCLT orders or whatever, there are, of course, individual cases where individuals have flouted basic rules of which need not even be written, that, if the registered valuer has to be appointed by a certain date, then it is inbuilt in that the cost of that has to be approved by that. It's been built. One doesn't have to tell it. Nobody is going to tell that, you employ somebody for services, but I will not pay for it. So that being, absurd in its, at the initial stage itself cannot be a reason. Now that is there. Okay. But apart from that, there are individual cases definitely where the RP and the COC have not got along for a variety of reasons, not all of which are documented and not all of which can even be documented or even brought on record. Okay. And whatever people use, whatever weapon they have. If you can't do one way, you do some other way. There are also instances where known of one or two, individuals, okay, not institutions. Individuals have representing the COC in the meetings, etc., or were tasked with getting the things done, have not behaved the way they ought. They have misbehaved. They have been deliberately confrontational, or even going to the extent of whatever reason may be. But in the large majority of cases, which have gone to the extent of being recorded, where one can only speak from public record, there have been a large number of instances where there has been a lack of communication between the two parties. What COC asks for, RP doesn't provide. RPs have gone to the extent of saying, I have decided, you only have to approve, put your rubber stamp. No, it doesn't work that way. It doesn't. When it says that the authority to appoint is on the RP, but the authority to approve expenses is on the COC, it means COC cannot tell RP whom to appoint, and RP cannot tell COC how much they should bear the cost. They are too independent, they have to come together. RP cannot, for example, put a valuer and say 15 lakhs. I have decided. You can't tell whom I should appoint. I have decided, you just have to approve. It doesn't work. In almost majority of cases, not all. This is the reason. The clash between the two, where they don't meet on minds. And if we do analyze it, we find that that the two have been confrontational probably from day one, in one form or the other. So that is there. But coming back to code of conduct, what shall it cover? One of them was not approving legitimate or statutory, both costs and fees and costs. IP, we will take it out because that is approved because of the code itself or the regulation. What else? The second usual most common complaint about COC, they take too much time, right? I think after fees and expenses, the second complaint about conduct of COC is the time taken in decision making. Right or wrong? Is that the second most common?
Yes, sir.
Yes, Mr. Narayan Swami, what do you think? Because I can see you, I'm addressing you. Otherwise, I can't even see the others. What do you think? Your experience?
Yes, I agreed.
Yeah, the second most common is delay.
Yeah.
Okay. Now let us look at all those who have worked in companies before, organizations, not own practice, organizations. Now you please answer that if you depute a representative for a meeting of COC and you have got 20 such things going on simultaneously at the bare minimum, maybe more, can you depute your CMD for every meeting? And if not, can you authorize the person whom you depute, who might be just a manager level or a senior officer level, to take decision on the spot?
Not possible.
So what are we complaining about? And again, we have to go by the larger sample, right? Exceptions are to be taken out. The majority of cases, they do take 7 to 10 days, yes, to decide. Does anybody know the amount of paperwork they have to do for getting that decision approved in their own internal system? It's significant. And is prescribing a time going to make it faster? What is the most likely thing to happen? Saying no, because it is easier to say no. Saying yes is a decision. Saying no is a reaction. Easiest thing to do. Okay, nahi karte hain. All will be voted down. So code of conduct, whether it prescribes timelines for judiciary or COC, because COC is not individuals, IPs are individuals. Big difference. An individual can be prescribed with a timeline where there is an institution involved with a procedure for taking a decision. Whatever be that procedure, that's a separate issue. Can we prescribe it by fiat? कि नहीं आप इतने में ही करोगे, बोलेगा ठीक है हम ना वोट कर देते हैं, करते रहो till we understand it. So this is the inherent danger in proposing what is called a code of conduct. Is one of the dangers. That's what it shall be. And second is enforceability. You can write it there. There are codes of conduct written for everybody. Now, there is a code of conduct written for the IPs in both the code and the regulations. फिर भी every week there is one DC order, which means code of conduct is not being followed. So how do we expect that it will be, implemented in full letter and spirit when institutions are concerned? So sometimes the cures can be, they look nice, we have done something, but that something is of no use. Okay. Next one is pre-pack for all. There is a suggestion that, only for MSME, kyun, sabke liye hona chahiye. How many pre-packs for MSME? Now that it is there for almost 1.5 years, right? Maybe 2 years. How many have been approved? How many have been filed? Okay, approval to dur ki baat. How many have been filed? Easiest to do for MSME. That's why it was introduced for MSME first. Usually one borrower, one lender and the borrower, between them, they can actually come quickly to a decision on a pre-pack. How many filed? Almost zero today. To the best of my knowledge, it is zero.
2 cases, I think, sir, have been admitted so far.
Okay, so 2 in how many months? 18 months, 20 months, roughly, whatever, more than a year. If that is the only experience we have, just admitted, is it premature to think of having it for others? Before we have certain learnings from the smaller, the MSME was intended to be the pilot. Learn from the pilot before you do the big one. So pre-pack for all, is it the right time? My own opinion, question mark, not at all the right time. Not till at least 20 to 30 cases have got admitted and have gone through the process for the MSMEs. Otherwise, we will continue to be meddling with the code because there will be problems that will come up. By the way, all those who are still present and not logged out, what is the reason for a pre-packs not being, people not going in for pre-pack till now? Why? Kya lagta? Fundamental reasons. They're pretty fundamental. They had to be. जब कोई नहीं कर रहा है तो.
So one, OCs have all to be paid. So that is one major, reason.
पैसा देना पड़ता है pre-pack. Yes.
And then I don't even know what's going to happen because the Pandora box is open and I could still go into resolution. I could still go into liquidation. There are n number of possibilities. There's no guarantee for anything. So one is that I have to pay, and the other
guarantee. See, that no guarantee is not strictly true because, see, the option for going for a open, invitation is only if the original plan, the base resolution plan of the corporate debtor does not provide payment of operational creditors in full. Only then. See, so But otherwise, it's not. It's you are the only one to give a plan. In BRP, assuming that one, maybe two lenders and the CD, okay, small MSME, it should actually have sailed through. There should have been hundreds of such applications filed and approved by now, actually.
No, but actually it is this is RSDB Gowda. Okay, sir. It is actually initiated by the CD.
Yeah.
So because he goes as per his whims and fancies. So that is one of the things which is not being popular. I mean, not get popularized. I say that.
No, everybody knows. One misconception, let me remove from all IP friends. The promoters know more about the code than us.
Yes, exactly. It is
Very
They
well.
know. Okay. So they don't know, ye wo kuch nahi hai, wo dikhate hain. Okay.
Yeah, very
See,
clever.
that which affects a
Very clear.
person, they do take the effort to learn about it. So they know. Let's take that for granted. They know about the scheme. They know about it. They also know why they don't want to do it. They're very clear. See, they might do an OTS because 1-to-1, right? If that is the stage, they might have a restructuring, not an OTS, but a restructuring between them and the lender. But they don't want to go and make a commitment of payment to all the operational creditors, many of whom they don't intend to pay.
Yeah.
For some reason or the other. Okay. This is the single biggest reason for prepack not being popular in India. And that situation is not going to change. Even in a Section 10 application today, it is almost like a prepack. Almost, I said. Yeah, you have to cede control to a third-party RP. But
under Section 10, the CD who initiates, he wants IRP under his control. He wants to direct him. That is what. In one of my cases, I thought he has gone up to complaining against me to IBBA. Later, IBBA started investigation and inspection, and he said that he has violated all the provisions. Later, they concluded there is no violation of provisions by IRP. So this is the one, as you rightly pointed out.
this will happen. It is like this, that if I invite you into my house, I don't want you to take over my house.
Yeah.
I want you to behave like a guest.
Yes, exactly.
So they want the RP to behave like a guest. Now, if you become an owner of a business tomorrow, you will have exactly the same attitude. Exactly. So let us be very clear. Self-interest, okay. So his self-interest is to behave like that. Our self-interest is different. And then there is the national interest, which hardly anybody cares about. So there are issues. The point is that prepack has issues, okay, by its very nature. That it can only, it is actually a restructuring with its stamp of the judicial authority, nothing more. But because it has the stamp of the NCLT, it becomes a little more binding on the corporate debtor. It includes acknowledgement of all the debts, which in normal course they will dispute when recovery action takes place. So any civil suit for recovery against any CD in the country for any debt whatsoever starts off with a defense saying, "Ye to dena hi nahi hai."
Yes.
You dispute the debt, you on any ground. It could be time barred, it could be quality issues, delivery issues, contract not performed, vagera vagera. So these things are there. And in a prepack, you as the borrower or the corporate debtor are giving under oath and by signature that these are my debts. So you can't turn back from that tomorrow, and nobody wants that to happen. So the reason for failure of prepack mechanism is inherent in the mechanism itself. It's there. The prepack is for basically honest borrowers, very, very endangered community. So problem. So if you expand it to the larger arena, it will follow the same fate. The bigger you are, the more your problems. So a lot of people will talk, oh, prepay karna chahiye. That's just buzzwords. Mostly to hide our own inefficiencies in taking the existing thing forward. Whatever is there, we are not able to do that properly. So we try to hide by saying Naya project. Not very different from politicians doing cutting ribbons, at the end of the term, diverting attention. Okay, so we have covered all those which were there, which apparently are under the consideration of the government to be placed before Parliament. And very briefly, I have sketched out some other issues which are equally or probably more important and which are relatively easier to sort out. So first is the inter se right of secured credits. First charge, second charge, this issue. It's hanging on for 5 years. There are pronouncements of the Supreme Court in the earlier regime of Companies Act, which is not very different. The waterfall under Companies Act, whether it is 1956 or 2013 or Section 53 under IBC, there's not much of a difference. Okay, except the major change of putting government dues explicitly at a lower level in 53. Other than that, it is largely very, very similar. So pronouncements under that act would, in terms of substance, apply equally well to IBC. But a lot of litigation on this, we know about that. Now, of course, thanks to Rainbow, which really speaking did not say anything new, what is the status of government secured creditors? Another issue which needs to be clarified. Okay. No amendment probably is necessary, in my opinion. Now, applicability of limitation law to claims during CRP and liquidation. This is, I am talking of not at admission stage, but when the IRP, RP or the liquidator admits claims, are we taking this into account? Is it even applicable? If so, to what extent? And here I would like to state something, that the original draft of the IBC regulations especially was that proof of claim. It did not really talk of admission of claim, because admission is a process that as such is not envisaged even internationally in insolvency law. It's always debts need to be proved, and proved means evidence of that yes, there is a debt. The aspect of limitation, to the best of my knowledge, has not been ruled upon, at least in India, in insolvency, that should the RP, IRP, RP or liquidator accept time barred debt. And if CIRP is not a recovery proceeding, then because limitation applies to recovery, not to resolution. Should it be there? Should it not be there? So some clarification on this. Sooner or later, this will come up. Then about the PF and gratuity dues. Okay, so many litigations going on for something, as I said, which is crystal clear. And thanks to one usage of one wrong word, or maybe a better word, that it talks of, the liquidation estate does not cover dues from the provident fund. Now, because it says from, everybody thinks it should be there in a particular fund, and hence here. Just by say from, if it is replaced by to, probably, that issue will be put to rest. Yeah, another one, late entrance, last minute, not even last minute, beyond last minute entrance. So is there any sanctity to timelines? And the word maximization, how it has been misused by everybody. In the garb of maximization, I can enter whenever I feel like, present a plan, apparently after I know everybody else's plan and all the details and issues, then I will come and say, I'm giving 1 rupee more or 5 rupees more or whatever. And then you have to consider my plan because it is maximization of the assets of the corporate debtor. So big issue this. Then 32A. 32A is a substantive provision under IBC which talks of what protection is available to a resolution applicant under two conditions. Okay, 29A obviously, and also that they should not have been involved in the management of the CD prior to that. How do you get the benefit? That procedural part is a gap in, and probably this is what needs to be addressed by way of regulations as to how they go about asking for this protection. Then a recent one, problem of liquidation and other reports to be filed as IAS, especially when there is no relief sought in such a report. Then one, why should the NCLT be burdened with more paperwork? And there is a huge cost of filing such a report as an IA. If it was only to be electronically filed, the cost would be probably what, maybe 100 rupees max for the entire process. Now it's around 15,000 rupees. There is the cost of IA, 2 copies, notarization, and then most IPs engage lawyers to present their so-called report when it gets listed. And all that is said is this may be taken on record, and the bench responds, okay, taken on record. And time lost and around 10 to 15,000 per IA excess cost from the system. Because ultimately the people of India bear this cost. It's all part of liquidation process cost. Yeah, so that ends whatever I had as a presentation. So for all those who were patient enough to hear and keep their minds here, thank you very much. And for all those who came in only for CPRs, thank you also. Okay, if there is anything left, if you want to ask any question from me, yes, you can go ahead. Yes, anything you want to ask, say something? Okay, that seems to be it then. There are no questions, no comments, nothing. So I will hand it over to the host. Peer, you can take over.
Yes, sir. So if there is no question to ask from our expert, then can we conclude? Or if anybody want to ask anything related to this topic or any other issue which they want to discuss pertaining to this theme of this series, so they can ask from our expert.
So where will we stand even if all these proposals come through? Where does IBC stand? Will it still require another couple of years of maturity before it becomes more viable, or how do you see it?
Okay, let us look at Companies Act. I'm talking 2013. Any idea how many changes it has undergone from the time it was introduced? Company secretaries will tell. There is almost some change every month on an average. See, we are so creative. We will find a way out of every provision that is made. So the lawmakers are left, just doing catch up. So it will continue to change, modify, evolve. Some out of circumstances, some out of learnings. Okay. Sometimes as something as small as drafting errors, which are misinterpreted, that needs to be corrected. Hey, these things happen.
Anybody else? Anything they want to discuss?
So if you could shed some light on latest any of the latest case laws that you found interesting, like Venus, of course, and then.
Well, that's a different topic altogether. But I did refer to Venus recruiters today because it was part of the it was relevant to one of the discussions we were having on avoidance transactions continuing beyond CRP period and who can continue that. Those two issues we dealt with. Other than that, there was nothing which was relevant to, not that I can offhand recall. Yeah, Jet Airways we mentioned, the first item itself. So 2 case laws we did refer to.
Relevant case laws will be discussed in one of another session in this series, sir.
Okay, thank you all very much. All those who are there and all those in absence also there.
Thank you, sir.
Thank you, sir.
Thank you so much.
Thank you, sir.
Thank you so much, sir.
I would like to extend my gratitude to Mr. Ravi Prakash Ganti, sir. Thank you so very much, sir, for such an interactive session. We are grateful for the time and effort you took to share your thoughts and experience on the subject with our members. Personally, I have learned from your session. We look forward for your support and association with us in our future programs also. Thank you once again for your contribution. Before I conclude, I would like to thank all our participants for attending this series. Tomorrow we will be having another most important topic of this series, which is scope of mediation as a precursor to CIRP. The session will be taken up by another expert, Mr. Sanjeev Ahuja. This session will start from 2 p.m. So thank you so much, everyone. Hope this series will be beneficial and provide useful information for our members. Thank you all. Have a great evening.
Thank you.
Thanks.
Thank you. Thank you.
Thank you. Thank you all. Thank you all.